Manchester High School issues.
Madam Chair, I have something I'd like to put on the projector screen if we can. And, while that's coming up, I'd like to make the following motion, and then if I can get a second, I'll speak to it. I motion that the Hooksett School Board direct Superintendent Littlefield, with the assistance of the district's attorney, to write a letter to the State Board of Education informing the board that we are referring the contract dispute with Manchester to them under paragraph 4C and 14 of the Manchester High School Maintenance Agreement. Further, that we request a hearing at the earliest convenience. The letter shall be ready for the board members to approve via email by 3/12/13. Upon approval, be sent to the State Board of Education and CC to the chairman of the Manchester School Board of School Committee.
A second for discussion, sir.
Thank you. For the benefit of the public, I put this up on the board, and I hope you can see it. This is what I'm basing this action on. As you can see in the 2/15/13 letter from the Manchester Board of School Committee, it stated that the Manchester Board of School Committee denies the claim that it has breached the high school maintenance agreement with the Hooksett School District. That's very clearly stated. Because of this, we need to look at the high school maintenance agreement, paragraph 4C, which states that if any other party to this agreement, including the Manchester School District, disputes the existence of the asserted material breach or default, the dispute shall be submitted to resolution under the terms of paragraph 14. When we look at paragraph 14, which is the next one on the bottom, disputes, should any school district have a complaint as to the operation of the agreement or the calculation of the district share of expenses, that complaint shall be stated in writing to the Manchester Superintendent of Schools. If the Superintendent of Manchester School District and the Superintendent of the complaining sending district cannot resolve this dispute, it shall be presented to the Manchester School Board, which shall in good faith attempt to resolve this dispute. Should this resolution prove impossible, the dispute shall be referred to the State Board of Education for a decision in accordance with Administrative Rules ED 200, which decisions may be appealed to a court of competent jurisdiction. So I am looking at Manchester's letter and the actions that our superintendent has taken with Dr. Brennan from Manchester to try to resolve this issue. And I've come to the conclusion that our superintendents were unable to resolve this. I'm looking at the letter from the Manchester Board of School Committee, which denies that a material breach exists. And therefore, I'm making this motion to refer this matter to the State Board of Education for our contract. That's all I have.
Now, if we were to make this, approve this motion, who do you think should write that letter? I'm not saying we should or we shouldn't, I'm just...
Well, my motion directs the superintendent to write the letter with the assistance of the district's attorney. I think whatever letter is written would end up being from the superintendent, but obviously he is going to want to seek the advice of the attorney, being that it's a legal matter. I think quite clearly by the contract that this is the avenue that we're supposed to follow. As I look at the contract, the 180 days is only going to be relevant if Manchester agreed that they were in breach. Because 180 days is a remedy period. But because they have denied the assertion of material breach, in essence, in their view, there is nothing to remedy. And that's where the contract states that we move to paragraph 14, which says that we refer it to the Board of Ed. So that's why I'm following this path.
Now, Dr. Littlefield, I don't have the letter with me, but the letter that Manchester sent to us, was that CC to the Department of Education, or was it just sent to the Hooksett School Board?
I believe it was just sent to the Hooksett School Board. And in fact, I do happen to have the letter with me. And it was CC, the letter was through the Hooksville School Board, CC to me and to the Manchester School Committee. That was it.
So I'm not sure what our first step should be. Should we notify the Department of Education that they're denying that we say there's a breach? Do we jump right in and say they've denied, we want you to hear us? Or do we refer this to our lawyer?
Well, I'm willing to guess that Dr. Littlefield will probably include the Manchester letter as proof that they have denied the breach. It's pretty clear when you read that letter, the quote is that they denied any assertion of breach. So, to me, it is time to refer it to the Board of Education and seek a hearing. I don't think that there's any benefit in waiting 180 days. I don't think it's relevant under the contract, and I don't think that there's any remedy that's being taken place. So at this point, I think we should refer it to the Board of Ed.
Cheryl, you have anything?
I'm just trying to formulate my thoughts. I guess I do have some concern with doing this at this moment. We didn't get to have our non-meeting today, which I would have wanted to refer to our council regarding this and whether this truly is the next move. So I am hesitant. Although, however, at the same time, under the Manchester High School issue, I did want to discuss what else we should be doing or could be doing. I did also hear about some things that Cambia did that I found very interesting and wanted to bring up and discuss as well if we could do them, simply because we did already deploy breach, number one, but number two, if that was also another avenue we wanted to go down. So at this time, I would not be able to support this motion.
Just for the benefit of the audience, we had a SAU meeting at which Candia was present, and they shared with us how they're dealing with the Manchester problem. And to paraphrase what was said, they have not filed breach, but they're writing letters to virtually everyone that they believe is involved. Their state representatives, the Board of Ed, and all of these types of things. I would say that they are in a different position because they have not filed breach. Having filed breach, we have filed a formal complaint, and therefore, I believe we need to follow the contract, which, as I put up here, stipulates exactly what we're supposed to do. And having received a letter from Manchester now, finally, we have got the answer about whether they agree whether we're in breach or whether we're not. So I think we're now compelled by the contract to move forward. And I don't look at it as my opinion. I look at it as I represent the citizens of Hooksett who signed that contract, and I have to interpret that contract and do what it says. So on the other side, I looked at what's the downside here. And I don't see a downside because if the Board of Ed answers our request and tells us that they're not going to take it up now or that they're going to take it up at another time, we will have a formal answer from the Board of Education as to what process we're now following. Right now, I believe if we're waiting 180 days, we are not following the proper process in the contract. So if that is the proper process, I believe let the Board of Ed tell us that, and then we will have that letter to go on. So that's why I think that we should refer this to the Board of Ed now.
Who would formally notify us that they believe it denied? I mean, does that formally come from the superintendent, or I would believe that letter would have come from the board, the Board of School Committee? That's the thing that concerns me. Is that really their official letter saying that they are denying the breach?
I have it here.
I don't have the letter in front of me, so I can't.
Go ahead.
The letter, excuse me, the letter does begin, and it is authored or signed by the superintendent. The letter begins with the Manchester Board of School Committee denies the claim, etc. So I think there are many times when I write a letter on behalf of the board. I have a tendency to write them on behalf of the board so that it's clear. But there's no doubt in my mind that this letter that we received on February 15th, that Superintendent Brennan was directed to write by the board.
Thank you.
I would also offer that the letter does not talk about any remedy. So not only are they denying breach, but they're not discussing any viable remedy to this problem. So I think that does prompt us to follow the contract and refer this to the Board of Ed.
Having just gotten this, I'm not sure I know what the right step to take is at this moment. But I'm wondering, David, if we, instead of, I know we have a motion on the floor to direct the superintendent to do it. Do you think it would be prudent to have him and the lawyer investigate that part of it and be ready to discuss it in our non-public meeting with him when we meet with him on the 19th?
Well, I guess I would say no, based on the language that I quoted from the contract. I think that when you look at the contract from the point where it says, if material breach is denied, if you look at it from that point on, it's very clear what you're supposed to do. So I think prior to the denial, there was a lot of supposing about what was going to go on. But I think when you look at the contract from that point, it says, if that happens, you must resolve it with Chapter 14. And if you go to Chapter 14, it says superintendents, the Board of Manchester, and if there's no resolution, if it's impossible, then it goes to the Board of Ed. I look at this letter from Manchester Board and I say, it's impossible. I didn't go into some of the other language that's in this letter, but there's nothing in this letter that gives me any gleam of hope that Manchester is on the way to resolving this problem. So when I read the contract, I can confidently say, yes, it's impossible that they're going to resolve it. We've seen Dr. Littlefield and Dr. Brennan have actually been assigned, I believe, twice to talk about this, and they came back 2 times with no resolution. So at this point, I think it's prudent for us to move it to the Board of Ed, and I'm confident that Dr. Littlefield can state our case in a letter with the help of our attorney. I mean, he's done a very good job of representing us in letters so far about class size and so forth. So I think we should move. I think the sooner that we can get a hearing on this problem, the better. Or if we don't get a hearing, perhaps we're going to get some further direction on where we're supposed to go. Unfortunately, our meeting with the attorney was canceled today. We are now looking at another 2 weeks. We're going to wait for that. And I'm able to read this information. I'm able to process it. I think it's very clear.